So today I am covering the topic of frequently asked questions regarding statutory construction in California. So basically, for those who are not familiar with the topic, I've put together a number of questions and their answers for queries that are most often posed regarding statutory construction here in the state of California. So first, what is the purpose of statutory construction? Well, according to the California Supreme Court decision, Smith versus Superior Court, they said the fundamental task is to ascertain the legislature's intent so as to effectuate the purpose of the statute. How do courts generally look at statutory language? Well, as a general rule, in reviewing the text of a statute, courts in this state will look to the ordinary or plain meaning. Do statutory headings in California's codes determine the meaning or intent of code sections? No. Things like the title, division, part, chapter, article, and section headings do not in any manner affect the scope, meaning, or intent of the provisions of California's 29 codes. Now, what is a code section? It's a designated provision, we call it a section, in one of the 29 codes. There are approximately just over 155,000 code sections amongst those 29 codes. What's a code subdivision? It's what comes under the section. So subdivisions of a section. And this is different from the federal United States codes or USC, which use the word subsection instead of subdivision. In California's codes, how are verb tenses handled? Well, the present tense includes the past and future tenses, and the future tense is deemed to include the present. In California's codes, how are gender pronouns handled? Until all the code sections are updated to reflect gender neutral drafting terms, the masculine gender includes the feminine and the neuter. In California's codes, how are singular and plural nouns handled? The singular number includes the plural, and the plural number includes the singular under California codes. In the codes, what does the word shall signify? Shall is mandatory in the California codes. And what does the word may signify? In the California codes, may is permissive. So are canons of statutory construction, used for construing the meaning of a statute? Yes, for purposes of statutory construction, the courts and bill drafters use a series of canons with a spelling of C-A-N-O-N, canon, to guide them. And these include what we call textual canons or extrinsic aids, intrinsic aids, linguistic presumptions, grammatical conventions, substantive canons, and extrinsic aids. What are the so-called clear statement rules? Well, these are canons that the United States Supreme Court has developed as an expression of quasi-constitutional values. What's an example? So what's the constitutional avoidance doctrine? Basically, it says that statutes will be construed whenever possible to avoid questions regarding their constitutionality. We often refer to this as just the avoidance canon. And so the fundamental principle of the constitutional avoidance canon is that a court should interpret the Constitution only when it is strictly necessary to do so. What are the so-called tiebreaker canons? They are used when there's a 50-50 split in interpretation of a statute. What's the rule of lenity? Penal or criminal law statutes, whose purpose is to punish offenders, of course, are to be construed by the courts strictly or narrowly. So the idea of this narrow interpretation is to apply any unclear or ambiguous criminal laws in a manner that is most favorable to the criminal defendant. What is the rule of the last antecedent? It provides that any qualifying words are to be applied to the words or the phrases that are immediately preceding the qualifying word or words, and they're not interpreted as extending to other words in that code section, for example. What is the serial comma rule? Well, when there's a series of three items or more where each is set off by a comma, then each item should be viewed as independent of each other. What's the whole act rule? It's a textual canon that provides that when you construe a statute, the text of the entire statute as a whole must be considered by the court, not just the individual words of perhaps one code section. What is the rule against surplusage? It basically says that if there is another reading of a statute that would avoid a perceived redundancy in the language, then the court is going to do so. What is the Latin canon adjustum generis? It says that when there are general words in a statute that follow particular and specific words, then the general words are to be confined to the things of the same kind as those specifically mentioned. What is the Latin canon called expressio unius? It says that when a statute includes a list of specific items, that list is presumed to be exclusive. So therefore, the statute applies only to the listed items and not to others that are not listed. What is the Latin canon called impari materia? Well, this is a doctrine of statutory construction that says statutes that are on the same subject must be construed together. In other words, if a statute is ambiguous, then the court may apply this canon and look to the rest of the statute or even the surrounding statutory scheme in order to determine the meaning of the ambiguous statute. What is the Latin canon called nocitur a socius? Here, the courts should interpret an ambiguous word or phrase by taking into account the words or the phrase's its use in the textual context. What is cognizable legislative history? Well, cognizable legislative history includes documents that the courts accept as evidence of legislative history and intent. The Third District Court of Appeal in California in the Kaufman and Broad decision describes specifically what materials are considered cognizable or non-cognizable legislative history for the California courts. Can the courts take judicial notice of proper legislative history materials? Yes, they can. What is an extrinsic analysis versus an intrinsic analysis of a statute? Well, an intrinsic analysis is one in which the bill language itself is interpreted by the reviewing court, while the extrinsic analysis is that which relies upon legislative documents such as committee or floor analyses. When do the courts apply general statutes versus specific statutes? A specific statute usually applies over a general statute. The specific statute is usually deemed to be an exception to the rule that is provided by that general statute. When do courts apply earlier statutes versus later statutes? Well, the general rule is that a more recently enacted statute is usually given more weight than an earlier enacted statute on the same topic. And finally, is the presumption that statutes apply retroactively as well as prospectively? Nope. California statutes are presumed to apply prospectively rather than retroactively. The presumption is against retroactive application of a newly adopted statute unless the legislature has plainly determined by express statement or other clear indicia that it was their intent to apply the particular statute retroactively. So those are my questions and answers or FAQs for statutory construction here in the state of California.